guys, welcome back to my channel. In the previous video, we discussed about the introduction of Indian Evidence Act and from section 1 to section 8. In today's video, we are going to discuss about the relevancy of facts from section 9 onwards. So let's begin with section 9. Section 9 says, facts necessary to explain or introduce the relevant facts are relevant. This section declares the following facts to be relevant. First point, facts necessary to explain or introduce facts which support or rebut an inference. Third, facts which establish identity of anything or person. Fourth, facts which fix time or place. And fifth, facts which show the relation of parties. So, according to section 9, evidence is always given of the fact which are necessary to. I'll explain all these 5 points one by one. So, first point is facts which necessary to explain or introduce. So, evidence is always given of facts which explains the principal fact or relevant fact or fact and issue, and facts which are necessary to introduce the principal fact or fact and issue or relevant fact. What are introductory facts? Facts which introduces the principal facts are all relevant. Let me explain you with an example. A has made a will of his property in the name of certain family member. So the fact that A has that property, second, fact which shows the state of such property and state of such family members. All these 3 points are relevant facts because these introduces the principal fact that A has made that will. Let's come to explanatory facts. Facts which explain the principal fact or fact and issue are relevant and can be given in evidence. For example, A has stolen certain goods. After that theft, A has asked his wife to hide those goods carefully. So this statement of A asking his wife to hide those goods become the relevant fact in the present scenario because it explains the principal fact that A must have done something or must have committed a certain offense. That's why he is asking his wife to hide those goods. Let's talk about the second point, that is facts which support or rebut an inference. Every fact which supports the inference or the principal fact or which rebuts or contradicts the principal fact or an inference are all relevant facts. For example, A is accused of murdering B. Then, after the murder, A has absconded from his house and is not to be found anywhere. So the fact that A has absconded from his house is a relevant fact in this case because this fact supports the principal fact or this fact supports the inference that A must have committed the murder of B. That's why he just ran away from his house. In the same case, if A makes a statement that on the given day he had gone to some ABC place for some work, this statement of A becomes relevant again in this present case because this statement rebuts or contradicts the inference that A has committed that murder. So all these things which supports the inference or rebuts or contradict, that is makes the inference opposite, is a relevant fact according to section 9. Let's talk about section 9.3, that is facts which establish identity of anything or person. So every fact which establishes the identity of a particular thing or a particular person are all relevant facts and can be given in evidence. For example, let's say an hypothetical name Ram Kumar. Ram Kumar has absconded from his place for last so many years and was not to be found anywhere. but all of a sudden, a person claims himself to be that Ram Kumar. Then the statement of every member or every person who was connected to Ram Kumar or who knows Ram Kumar becomes relevant fact in this section, because that statement of the person establishes identity of that person or establishes identity of Ram Kumar. Therefore, his statement becomes relevant according to section 9. And this establishment of identity can be by direct statement, or it can be according to the circumstances of situation. So any statement that shows age of the person, height of the person, complexion, occupation, or even handwriting of that person is a relevant fact according to section 9, because that statement to some extent establishes the identity of a particular person. One of the important and vital fact or say ingredient of section 9 is test identification parade, that is TIP, which is one of the very important procedures in criminal trial. What is test identification parade? I'm sure most of you must be knowing, but then those who do not know, TIP or test identification parade is mainly conducted to find out whether the person has committed the particular act or not. If the witness, see, there can be two possible things in every offense. Either the witnesses know the accused by name, or the witness does not know the accused. If the witness knows the accused, then obviously he will name the person in the court that so and so person has committed this act or an offense. But what if in case the witness does not know the accused, but he has seen the accused committing the particular act or an offense? So in that case, TIP or test identification parade is conducted for him to identify the accused. If he identifies the accused, first of all, how will he identify? Just because he has seen the accused committing the act, so he can able to recollect his features, he can tell his height or complexion or body build, something of that sort, which identifies the accused, or he can identify the accused merely by seeing his face in the test identification parade or TIP. So this statement of A becomes relevant fact according to section 9, because it is establishing identity of that accused. But one important thing, that this identification will not be the sole reason for conviction of the accused. It is mere relevant fact in that trial. Next come to fourth point, that is facts which fix time or place. Any fact which shows the time of happening of an incident, or which shows the place of happening of incident, are all relevant facts. Reason being, this helps the court to believe that the particular incident had happened at particular time, or the particular incident had happened at a particular place. Next we come to point 5, that is facts which show the relation of parties. So every fact, as it is very clear from the point itself, every fact which establishes the relation of the parties are all relevant facts and can be given in evidence. Next, move on to section 10. What section 10 says? Things said or done by conspirator in reference to common design. So in section 10, the conditions for relevancy under this section are: first point, reasonable ground to believe that two or more persons have entered into conspiracy to commit offense. Second, anything done by them after the time when such intention was first entertained by any one of them. Third, such act must have been done in reference to their common intention. And evidence of such act is given for the following purposes. Under section 10, the evidence can be given for the following purposes. First purpose, to prove that there is a conspiracy. Second point, to prove that such person was party to such conspiracy. So what section 10 talks about? it talks about conspiracy as a main theme. So what exactly is conspiracy? Conspiracy is both a crime as well as tort. According to section 120A of Indian Penal Code, conspiracy comprises of three things. First, two or more persons. Second, enter into agreement. Third, such agreement was made in order to commit unlawful act or a lawful act by unlawful means. So conspiracy consists of basically three ingredients. Now we come to section 10. According to section 10, anything is said, done or written by any member of conspiracy in furtherance of their common intention, then such thing is a relevant fact against all the other members of conspiracy, even if they're present in that act or absent, or they had the knowledge of such act or not. The mere fact that they become the member of conspiracy, then anything is done by any member of such conspiracy in furtherance of their common intention, it is a relevant fact against all the members of conspiracy. Next, come to section 11. Section 11 says, when facts not otherwise relevant become relevant. That means facts which were otherwise not relevant at all, but they become relevant if the two things under section 11 are fulfilled. First point, if they are inconsistent with the facts in issue or relevant fact. Second, if they make the existence or non-existence of the fact in issue or relevant fact highly probable or improbable. Let me explain you one by one these 2 points. First of all, this section deals with facts which are ordinarily not relevant at all, but they become relevant when, first point, if they are inconsistent with the main fact. This point consists of very important phrase, that is plea of alibi. Plea of alibi means presence elsewhere. Let me explain you with an example. In a trial of murder against A, wherein the murder took place in Delhi, then A can take the defense of plea of alibi by stating that on the day of murder or at the time of murder, he was present in Dubai because of his business work. So his presence in Dubai is inconsistent with the fact that he should be present in Delhi in order to commit the murder. This defense of A, defense of plea alibi, is a relevant point because it is inconsistent with the main fact. If he were in Dubai, then obviously it is just impossible for him to commit murder in Delhi at so and so place and so time or so and so date. Therefore, this inconsistency is a relevant fact according to section 11. Please note, plea of alibi under section 11 means presence elsewhere. Second, facts which make existence or non-existence of fact in issue highly probable or improbable. Let us talk about first highly probable. Example, where there is a question that A stole B's goods or say B's money, let's say. A has stolen B's money. The question is whether A has stolen B's money or not. The fact that A belonged to the gang of dacoits or habitual thieves of that area is a relevant fact under section 11 because it makes the principal fact that A has stolen B's money highly probable. Highly probable means this fact that A has belonged to the gang of thieves in that particular area. This membership of A in the gang of thieves is a relevant fact because this makes the principal fact, that is theft of B's money by A, highly probable. Highly probable, it strengthens the main fact. That is, if he is a member of the gang of dacoits or if he is a member of gang of thieves, then this fact strengthens the main fact that obviously A must have stolen these goods. But then again, this fact is a mere relevant fact, but this cannot be the sole ground of A's conviction. Similarly, there's another example. In a case of murder, when witness says that he saw two men entering into deceased room late at night, what has witness said? He said that I had seen two people entering into deceased room. Whereas the fingerprint evidence shows that there were fingerprints of three unknown people in B's room or deceased room. So this fingerprint evidence is a relevant fact because this fact makes the principal fact. Now, what is the principal fact in this scenario? The witness statement that he had seen two people entering into deceased room. This fingerprint evidence makes that principal fact or makes the witness's statement highly improbable. That means it weakens their statement that if there are fingerprints of three people, then the witnesses saying the presence of or entering of two people, it just weakens their statement or this statement becomes highly improbable. That's why this fingerprint evidence becomes a relevant fact under section 11. Let's talk about section 12 now. Section 12 says, in suits for damages, facts tending to enable court to determine amount are relevant. First of all, this section applies in civil suit because it talks about damages. Damages or compensation are the common relief in civil cases. This section talks about facts that help to determine damages are all relevant. So, first of all, it is always a duty of the court to make appropriate award of damages. Damages, as I told you, damages or compensation is a common relief in civil cases. So, every fact which enables the court to determine the appropriate amount of damages is relevant. Now, amount of damages, they are based on what? They are not though they are the discretionary power of the court, but then the amount has to be fixed in accordance with first, defendant's fortunes or riches, whatever property that defendant is having. Second, plaintiff's loss, what kind of loss plaintiff has suffered. Third, mental pain and sufferings caused by plaintiff. So these are the three things which are the basis for the amount of damages which are to be fixed by court. One last thing, onus. Here in this scenario, in the section 12, onus is always on plaintiff to show what kind of loss he has suffered, and according to that loss, he will be awarded the amount of damages by the court. So that's all for today, guys. I hope you have liked my video. Please don't forget to subscribe my channel and hit the like button so that I can keep on making such kind of videos which are helpful for you to understand what Evidence Act is in a simplest ever manner. Thank you for today. Stay tuned. Goodbye.